now proceed with Senator Alma Francis Heyliger. You're recognized for your 5 minutes. All righty.
So much. Good afternoon, colleagues. Good afternoon, testifier, and good afternoon to the people of this territory. Director O'Neill, earlier when you spoke, I think I heard you spoke about getting some legal advice as to whether this can or cannot be done. How long ago did you say that you had requested this advice?
No, and good afternoon, Senator. I didn't actually request legal advice on this. This bill had come up before, and the Attorney General and I had a conversation before.
Oh, it was just a conversation.
It was back in July, but we haven't had, nor did I ever request a legal opinion on this.
So since July that you guys have been aware of this, and you have not sought legal opinion, what is your current stance? I know what you shared with the public, and you spoke to you personally being held accountable for this. I want you to share with me, do you think that the legislature, the first branch of government, should be participating in the process to see how these funds are expended?
Absolutely, Senator. I would say the legislature should be involved. How is the question?
Oh, how? Okay. Well, thank you for that. Well, what would you tell me from your perspective? How do you believe the legislature should participate?
So, this is my personal opinion. Legislature should be included in the conversations. We should sit and review the plan that has been put forward so far. We should see if the legislature has other areas that they may see a need that we may or may not have covered, or you may want to add a little bit more to one area than another. So we can have those conversations, and I definitely see a need for that.
So from your perspective, and you clearly said this was your personal opinion, that this should be more of a gentleman's agreement where the legislature just sits down, have a conversation, and we hope that conversation is going to stick and the follow-through is going to be the case.
No, Senator, I must say, it's not. There's a huge level of oversight that is happening and has been happening by Treasury ever since the first sum of money came to the Virgin Islands. We are being monitored. We have to provide a report. We look at everything. We are talking to Treasury continuously. We are not trying, nor have we been distributing any monies without having approval. This is another reason why we even put an RFP out to get assistance with ensuring that we have everything matching what Treasury's guidelines are.
And I think that's where this piece of legislation was born, because everything you're discussing a lot of times has to do with we referencing the Treasury and the executive branch. And unfortunately, with the legislature being left out of the process, and understanding that we are the first branch of government, and understanding from our perspective, we should be very much involved when it comes to all of these funds, because we do deal with the purse strings of this territory. So from my perspective, as one of the sponsors of this legislation, I feel that this body should have some type of knowledge, information, oversight, whatever the case is. This is a lot of money. And when I, as a senator, am out in the streets speaking to my constituents, and they're saying, they're asking me, what are we doing with all this money that's coming in? And can I honestly tell them? And how does that work for me as their representative, when I can say, well, I know the governor and his people put in a plan, but I don't know. I cannot, in good conscience, give up that type of authority as a senator to to be their representative to make sure that this funding that is here on their behalf is actually being put to good use in areas that are necessary for them. Now, I have seen some of the different categories and all the, I think the other day even, I think it was some 40 million for internet. And I even saw where the governor had put out, we're going to be doing, but I didn't have any saying that. I had none. So this is where my concern is, because I can't be a senator that does not know. I can't be a representative that has no clue. And I think this body, and that's basically what we're all saying, that's why you saw 14 of us on this one piece of document. 14 out of 15 people is on this paper, because we need to know what is happening when it comes to the funding that comes into this territory to make sure it is put to good use, because we are the representatives of the constituents that voted for us. But I thank you so much for sharing your thoughts today, and I appreciate your testimony.
Thank you. If I could respond real quick, a little bit.
You may respond.
Thank you, sir. You know, we recognize that the role of the legislature is to enact the laws, but the executive branch's role is to implement federal and local laws and appropriations. You know, we did reach out last year, I think it was, and we got a response back from the National Governors Association relative to Treasury's intent after they did their research. And it was stated that, and I can provide this if necessary, but it was stated that Treasury's intent, based on the interpretation of the U.S. Department of Treasury, the Coronavirus Relief Fund for state governments is intended to be administered by the governor of each state. Thus, absent explicit statutory language or agency guidance, the White House statement underscores their position with respect to the governor's ability to administer funds so long as such expenditures are necessary. And this, again, I must state that these funds is to deal with the coronavirus pandemic. That's what the use is for, and everything that we have seen, and Treasury's intent as stated in some of the documents that we have received, it is for the governor to administer those funds, especially in instances where the governor has issued, or a state of emergency, I should say, has been issued.
Thank you very much, Director O'Neill. Director, I am definitely aware. We had a couple point of inquiries. Senator Francis Heyliger, you recognize for your point of inquiry.
Good afternoon. Point of inquiry through the chair to Director O'Neill. I remember you were here a few months back when I asked you a question as to how much of the monies can the governor spend in regards to, for example, the lotteries that happened, where over $1 million had been spent, because, you know, that was a efficient use of government funds. But what I'm asking you, how much, and I need for you to share just to, from my recollection and public information, how much can the governor spend out of these millions of dollars for things like that?
So, Senator, that actually, the way you put it, it's not just a lottery, or, you know, and I know you might have a difference of opinion on whether or not it was efficient.
We're all sharing our personal opinions today. You've done it several times today, so go ahead.
Stimulus in an attempt to get people to get vaccinated. We were not unique in that. A number of other jurisdictions done it.
Madam Director, I appreciate all of that, but the question I asked you, how much of these monies can the governor spend in regards to those types of lotteries? That is the question I asked.
The governor has the latitude to spend as much as he would like.
Oh, he has no limit. That is the point I was trying to get to. And the other thing I want to ask you is this. Any conversation that this body has with the governor outside of anything legally binding, Does he have to follow it?
Senator, I can't speak for the governor. I really can't speak for the governor.
Okay, I will accept that. Well, then could you share with me your personal opinion, since you've been doing it all afternoon?
No, on that, again, I can't speak for the governor, whether or not he can do what you say. That would be for the governor to determine.
Well, so basically, I'm going to finish quickly, because one of the reasons why we're doing this legally is because I could have a conversation with you and every single person in this body. But at the end of the day, if it's not legally set in stone, we don't have to agree to anything. We could just talk about it, but it doesn't really mean anything. So thank you so much for sharing your thoughts with us today.
Thank you, Senator Francis Heyliger. Who speaks to Bill number 34-0035 today? Senator Francis Heyliger, you are recognized with your introduction.
Thank you very much. Good afternoon once again to my colleagues, to the people of this territory. A few months ago, this piece of legislation was before this body, and what it's attempted to do, that there is a piece of legislation that is in our Virgin Islands Code for 100 years that spoke to the obligation and the requirement of a female to have to carry her husband's surname. Now, this piece of legislation, 100 years old, is rooted in a time where women did not have value, that the minute that they married their husband and took on their surname during that time period, they became one, and all the assets of the female, usually at that time, went to her husband. In modern day times, where you have individuals that choose and they have the right to carry various different last names, where they have the right to combine their last names. For example, I was born Alma Francis, Francis being my father's last name, and I made the choice to attach my husband's last name, Heyliger, to it, ergo Senator Francis Heyliger. And we also have that from another one of our colleagues here. According to how the law is written, basically what it does is it takes away a woman's right to choose simply because they were born female. And that is something that I believe that is antiquated and should no longer have any place in our books here in the territory. I will give an example of one of our individuals that continue to carry their last name as well, our delegate to Congress, Stacey Plaskett. Stacey continues to use her married name, but according to our VI code, she's actually breaking the law. And she's using her maiden name, Plaskett. And for many, she is married, and her husband, I believe his last name is Buckney Smalls, if I recall correctly. But based on how our code is written, this is not something she should be doing. And in modern day times and history, women should not be put in a situation where things like these are still in the Virgin Islands Code. So after discussion we had during the last meeting, this particular piece of legislation was written about in several news articles. It was discussed on several radio stations, and speaking with some colleagues, speaking with constituents, and the consensus was it does not match our modern day times, and it no longer needs to be in our code. So the decision was made to completely repeal that line out of the VI code, so it is no longer an issue for us, because at the end of the day, being born female, there should not be anything on the law books to tell you you have to do something just because of your gender. So I am asking my colleagues to support my request to repeal this. The amendment was made to the piece of legislation to simply just repeal it out of the VI code, and I would appreciate your support in moving this piece of legislation forward. Thank you very much.
Thank you very much, Senator Francis Heyliger. Payne, Senator Francis, you're recognized for your 2 minutes. Francis Heyliger.
Not him. I was confused.
I apologize for deleting your your Heyliger name. That was not done on purpose.
Oh, that's funny.
I'm sorry.
Listen, I'm going to have my husband on speed dial, okay? Good afternoon once again. I want to thank my colleagues. Becoming a senator and seeing a lot of things that are in the VI code that are outdated, and we try to pick up on many of them as we possibly can. But this was a no-brainer for me, and I really appreciate the conversations that I have with the public as well as conversations with my colleague to come to this resolution as the best way to resolve this. So I just want to say thank you to everyone that is in support, and hopefully we will continue to remove antiquated laws out of the VI code that no longer need to be there. Thank you so much.
Thank you very much, Senator Francis Heyliger. The mover of the bill must first give her introductions. I apologize, Senator Francis Heyliger. You may proceed with your introduction.
Good afternoon once again to my colleagues. Good afternoon to the testifier. Good afternoon to the people of this territory. This piece of legislation came about out of necessity. As a candidate over the years and just utilizing the Board of Elections for getting information and data, and sometimes when we needed specific information, at times we were told it was not available due to how the law was written. When I did some research and I looked into the law itself, I realized that the law was created on February the 20th, 1963. And a lot of things have happened since 1963 because we're in 2021. And this piece of legislation seeks to update and give more accessibility in regards to public information and the way the public can access it. One of the major things for me in making sure that the public has access to information has to do with transparency. As a voter, as a resident, as a constituent of these islands, one of the things I noted is that a lot of times during election times, the people have a dialogue speaking to feeling that things are happening at the Board of Elections. They have a feeling of things are not transparent and they want information. A lot of times these dialogue rises to conversations that speak. We had conversations about black boxes. We had conversations about missing ballots. A lot of things happen throughout this time period. But for me, I am a firm believer that I would like people to go out and vote. And I think the more we have access to information as residents of this territory, the more people will look at this information and say, you know what? Maybe something isn't happening that's bad at the Board of Election. Maybe I will go and register. Maybe I feel a lot more comfortable in saying that it's okay. But if we do get access to data and something does happen, we're aware of it and we are able to fix it immediately. So for me, it has a lot to do with public access and transparency. Now, I did get a chance, along with my staff, over the last 2 days to speak with Ms. Fox, because we did submit this back in October, I think October the 4th, to the Board of Elections. And we recently started to have dialogue in the last 2 days. And I have to say that the dialogue that we were able to have afforded us some additional necessary information that we were able to make necessary amendments to the bill so that we would able to make sure that the public has access to information that we believe is much needed. So I am going to look forward and listen to Ms. Fox as she gives her testimony on this piece of legislation. And I appreciate any open dialogue that we have today, because at the end of the day, access and transparency is the key to voter turnout. And that is my ultimate goal, for people to have the opportunity and the feeling of security of saying that their vote is secure and safe when they go to those polls. Thank you very much for the time.
Thank you very much, Senator Francis. Senator Francis Heyliger, you're recognized for your point of inquiry.
Thank you so much. Point of inquiry to the chair, to the testifier. Could you please share, I'm going to tell you factually, nowhere in this piece of legislation has requested anyone's phone numbers or their emails. There's a section that speaks to the individual that is coming in to request the data. And when they request the data, all it says is they need their name, their physical address, mailing address, and phone number. And it only speaks to the person that is requesting. You also certified examination document in regards to the requester from the Board of Elections. And on that document, it also requests the phone number. We were just codifying in the code the very information that is on the form that was provided by the Board of Elections. So I'm asking you, did you see anywhere or anything we discussed that my legislation said that phone numbers and emails should be given out?
Senator Francis, that's exactly what I said. I said there's nothing on you. I've said the AG address phone number, not your document. Okay. I said the concern with your document is in 10 days and not having qualified elector in the amendment. I haven't seen your last amendment since we spoke on the 6th. So you are correct. I'm not saying your document. I'm just saying that was the AG's opinion.
Okay. Thank you so much for clarifying that, because there was some kind of communication where it gave the impression, based on how it was relayed to the public, that my bill was requesting that, when it clearly does not. Thank you so much, ma'am.
Thank you very much.
Thank you.
Thank you very much, Senator Francis Heyliger. Senator Francis Heyliger, you're recognized for your 4 minutes.
Thank you so much.
You're welcome.
Good afternoon once again to the people of the territory and to my colleagues. You mentioned two things, and I wanna jump in quickly on the first part in the piece of legislation that spoke to the 10 days. After speaking to you, one of the compromises we made was we put 10 business days, which translates into 2 weeks. And by your own thoughts and sharing of the form, you said you guys tried to do it within a 7-day period. One of the reasons why we felt it was important to put a time frame in there is because of the very reason a lot of times when people do come to the Board of the Elections, it is time sensitive for them as well. I could be a candidate in need of information and data smack dead in the middle of a campaign. I could be, and one of the things that why we felt it was necessary, we also would like to make sure the public knows that there's some sense of urgency when they come and make a request, as opposed to just leaving it open-ended, where I understand that you guys tried to do it 7 days or earlier, but something could come up and we don't really know what the case is. So that's why when you suggested we completely remove it, I still felt it was important to have some time certain date, and we did include the word business, which would give you actually 2 weeks. And the things that are usually requested a lot of times are copies. For example, in the piece of legislation that we have, I went and I requested all of these documents from the Board of Elections. They consist of registered voters that went to the various precincts. I had to give paper because these were one of the sections where you had to fill out the form and request it. Things like these we're not putting online. They're going to stay underneath the category where people have to still come in and request.
2 minutes.
You spoke about funding. 80% to 90% of the things that you spoke about that you would need funding for are already online. So I'm trying to understand, did you calculate some kind of number as to what kind of finances you're looking for? Because we really did an audit of the current website, and some of the information the majority of it is already there. We just want to make sure codify it in the code, because as of right now, when it's open-ended, again, depending on what board is there, they could pick and choose what goes or what doesn't go on the website. Something else I wanted to touch on quickly. In your testimony, you spoke about what the current law says. It says documents in its custody shall be open to public inspection and may be inspected and copied by any qualified elector. The reason why this piece of legislation attempted to eliminate the word qualified elector is because that very sentence alone is contradictory. When you say something is publicly open, but then you discriminate and say only a registered voter can have it, that completely clashes within the same sentence. So I'm trying to understand that if people are taxpayers, not every single person is a registered voter. I could be an individual that wants to come up and get a copy of information so that, hey, let me see how this system works and say I'm secure with it. I'm going to go register to vote now. I should have that option as a taxpayer. And why do we need a document in the books to discriminate against someone to say whether they're registered or not? There are people that are, like, I'll give you an example. My legislative director recently relocated here to the Virgin Islands. She has to meet her residency requirements. She cannot even go to the Board of Elections and get data just to help me with this piece of legislation, because currently right now she's discriminated against because she's not a registered voter. So why do we think that this still needs to be in the code when it's clearly a tactic of discrimination? We cannot keep doing these things. If we find things are flaws in the code, we clean them up. And that is what I'm attempting to do today. So I understand what you're saying, that if these two things were changed, you would support the bill, and I appreciate it. But I can't, in good conscience, say that I'm going to continue a piece of law that clearly discriminates between a voter and a non-voter, but in the same sentence tell them it's open to the public. Something is clearly wrong there. So I am just trying to resolve and clear something up. The last thing I want to touch on, may I continue,
You
sir?
may conclude. You may conclude.
Thank you. You did about 4 pages on cloud computing. I would like for you to share with the public. You stated that currently, right now, the Board of Election uses the electronic format. In the piece of legislation, it says electronic format or cloud computing. With that statement, does it obligate you to change from the electronic format that you're currently in? If the option is the word, it does not. So the reason why cloud computing was put in the piece of legislation is because it is part of industry standard. So I am not going to write a piece of legislation for today, just for today. I am not going to write a piece of legislation because you, as the Board of Election, currently only use the electronic format. We might have better security for cloud computing in 5 years, 10 years, and this might not even be a discussion, but it's in the code, so you will have the option to use it. So I was very much confused at the 4-page dissertation on cloud computing when it's not even something you utilize right now, and the law doesn't require you to even change from the electronic format. It just simply says or, so that in the future, if you ever choose to use it, you have the option. That is all the law says. I mean, the piece of legislation says. So I want to thank you for really, sharing your thoughts, and my time is up, and I will wrap up in my closing. Thank you so much.
Thank you very much, Senator Francis Heyliger. Quick point of inquiry.
For informational purposes, I want to inquiry to the chair. If someone from the news, nationally, locally, or the media comes our voting.
I'm not hearing.
I'm sorry. Can you hear me now? Sorry. If someone from if someone from the news media, if someone from whether national, local, comes in and fills out a form for a request to get basic voter information here, somebody has a research paper, something, whatever it has to be done, are they denied on the fact that they're not registered to vote in the Virgin Islands, or do you give them the information?
Well, the newspaper is based, say the Daily News. So the Daily News might be owned and operated by Virgin Islanders. So the person that may work there, the news has access because they are news media. So they get the information. But they do not ask for data like a voter's data record. They ask for general information, so they don't ask for voter history, voter information on any particular person. That's the difference.
So you're telling me that a newspaper has never come in all of these years and asked for voter list? They've never asked for it? And I'm trying to understand what you're saying. I know you've only been there a couple years. Oh, not to your knowledge.
Correct.
Okay. Thanks for that clarity.
Okay. Senator Francis Heyliger, you're recognized for your point of information.
Thank you. I just want to quickly thank my colleagues and the testifier for coming in regards to this piece of legislation. The decision was made to hold it so that the supervisor of election can have an opportunity to view the last final amendment. And at the end of the day, I am happy as to the outcome where we're having this conversation. And it is my hope that once we have a final review, we will be requesting that it be called back before this committee. Thank you so much.
Thank you very much, Senator Francis Heyliger.